The Supplementary Protocol on Liability and Redress in brief. Liability is the state of being legally responsible for something or answerable in law. Legal liability concerns both civil law and criminal law. A civil action is a lawsuit seeking monetary damages for injury or loss that the plaintiff alleges the defendant caused. A defendant who loses in a civil action does not face the risk of prison or fines. By contrast, a criminal action is a prosecution of an individual for violating a provision of the criminal code. The penalty that a defendant faces in a criminal action may include prison time, a fine, or other terms. There are two types of liabilities. 1. Fault-based liability, where the plaintiff must prove that the defendant's conduct was either negligent or intentional. 2. Strict liability, where the plaintiff must prove that it was the defendant's object that caused the damage. For example, the product liability, which is the area of law in which those who make products available to public are held responsible for the injuries those products cause. The objective of the Supplementary Protocol is to contribute to the conservation and sustainable use of biological diversity by providing rules and procedures on liability and redress. Providing rules and procedure for liability and redress is a mean to achieve the overarching objective of conservation and sustainable utilization of biological resources, which is a central objective of the two parent treaties, namely the CBD and the CPB. The Nagoya, Kuala-Lumpur Supplementary Protocol delineates two pathways to dealing with damage: the administrative approach that empowers a competent authority to deal with the matter administratively, without initial recourse to courts, and a civil liability approach that requires litigants to seek private law remedies through national legal systems. The elements of the administrative approach are specified in Article 5 of the Supplementary Protocol. Article 5 deals with how, when, and who should take response measures in the event of damage or sufficient likelihood of damage resulting from living modified organisms that find their origin in a transboundary movement. This provision, together with the definitions of damage and response measures, is believed to be the core of the Supplementary Protocol. Additionally, the Supplementary Protocol has an enabling article on civil liability. Damage means an adverse effect on the conservation and sustainable use of biological diversity, taking also into account risks to human health, that is measurable or otherwise observable, taking into account, wherever available, scientifically established baselines recognized by a competent authority that takes into account any other human-induced variation and natural variation, and significant. A significant adverse effect is to be determined on the basis of factors, such as the long-term or permanent change, to be understood as change that will not be redressed through natural recovery within a reasonable period of time. The extent of the qualitative or quantitative changes that adversely affect the components of biological diversity. The reduction of the ability of components of biological diversity to provide goods and services. The extent of any adverse effects on human health in the context of the protocol. The inclusion of such qualifiers as or observable and, where available, softens the otherwise stringent requirement of science-based proof of damage. Response measures means reasonable actions to prevent, minimize, contain, mitigate, or otherwise avoid damage, as appropriate. Restore biological diversity through actions to be undertaken in the following order of preference. Restoration to the condition that existed before the damage occurred, if not possible then to its nearest equivalent, and if not possible with other components of biological diversity for the same, or for another type of use either at the same or at an alternative location. Operator is defined in the Supplementary Protocol as any person in direct or indirect control of the living modified organism. The determination of who the specific operator might be in any given circumstance is left to domestic law. An operator could be inter alia, the permit holder, person who placed the living modified organism on the market, developer, producer, notifier, exporter, importer, carrier, or supplier. This supplementary protocol applies to damage resulting from living modified organisms which find their origin in a transboundary movement. These includes intentional transboundary movements such as living modified organisms that the country has imported for planting or breeding purposes or for use in contained facilities such as in research in laboratories or for direct consumption as food or feed or for further processing or for LMOs. And to damage resulting from illegal transboundary movements as referred to in Article 25 of the Protocol, as well as damage resulting from unintentional transboundary movements as referred to in Article 17 of the Protocol. This supplementary protocol applies to damage resulting from a transboundary movement of living modified organisms that started after the entry into force of this supplementary protocol for the party into whose jurisdiction the transboundary movement was made. This supplementary protocol applies to damage that occurred in areas within the limits of the national jurisdiction of parties. Domestic law implementing this supplementary protocol shall also apply to damage resulting from transboundary movements of living modified organisms from non-parties. A causal link shall be established between the damage and the living modified organism in question in accordance with domestic law. It emerged during the negotiations of the supplementary protocol that parties to the protocol hold different understandings of the application of Article 27 of the protocol to processed materials that are of living modified organism origin. One such understanding is that parties may apply the supplementary protocol to damage caused by such processed materials, provided that a causal link is established between the damage and the living modified organism in question. The central obligation of parties to the supplementary protocol is to provide for response measures in the event of damage resulting from LMOs, or where there is sufficient likelihood that damage will result if timely response measures are not taken. To that end, parties to the supplementary protocol have to make sure that the competent authority identifies the operator which has caused the damage, evaluates the damage, and determines which response measures should be taken by the operator. The competent authority may implement appropriate response measures, including, in particular, when the operator has failed to do so and has the right to recover from the operator the costs and expenses of, and incidental to, the evaluation of the damage and the implementation of any such appropriate response measures. Parties shall require the appropriate operator or operators, in the event of damage, subject to any requirements of the competent authority, to immediately inform the competent authority, evaluate the damage, and take appropriate response measures. Response measures shall be implemented in accordance with domestic law. Implementation and relation to civil liability. Parties shall provide, in their domestic law, for rules and procedures that address damage. To implement this obligation, parties shall provide for response measures in accordance with this supplementary protocol and may, as appropriate, apply their existing domestic law, including, where applicable, general rules and procedures on civil liability. Apply or develop civil liability rules and procedures specifically for this purpose, or apply or develop a combination of both. Parties shall, with the aim of providing adequate rules and procedures in their domestic law on civil liability for material or personal damage associated with the damage as defined in Article 2, Paragraph 2, b. Continue to apply their existing general law on civil liability. Develop and apply or continue to apply civil liability law specifically for that purpose, or develop and apply or continue to apply a combination of both. The Biosafety Clearinghouse is crucial for the implementation of the Cartagena Protocol on Biosafety and its supplementary protocol. It serves to maintain data on activities involving LMOs and operators, maintain criteria on monitoring and evaluation of damage to biological diversity and human health, maintain a mechanism for notifying and consulting with affected or potentially affected states in the event of incidents, Article 17 of the CPB. Inform operators of their obligations and available remedies as well as laws and regulations. Make available information on incidents of damage to biological diversity and appropriate response measures taken or to be taken. Make available information on incidents of illegal transboundary movements, Article 25 of the CPB. Promote public awareness and education concerning damage to biological diversity resulting from LMOs and act as source for information on the likelihood of occurrence of damage. Article 5.3 of the Supplementary Protocol.